Freedom of panorama is a provision in the copyright laws of various jurisdictions that permits taking photographs and video footage and creating other images of buildings and sometimes sculptures and other artworks which are permanently located in a public place, without infringing on any copyright that may otherwise subsist in such works. And to publishing such images, better source needed. Panorama freedom statutes or case law limit the right of the copyright owner to take action for breach of copyright against the creators and distributors of such images. It is an exception to the normal rule that the copyright owner has the exclusive right to authorize the creation and distribution of derivative works. The phrase is derived from the German term Panorama-Freiheit. Laws around the world. Many countries have similar provisions restricting the scope of copyright law in order to explicitly permit photographs involving scenes of public places or scenes photographed from public places. Other countries, though, differ widely in their interpretation of the principle. European Union. In the European Union Directive 2001/29 (EC) provides for the possibility of member states having a freedom of panorama clause in their copyright laws, but does not require such a rule. Panorama-Freiheit is defined in Article 59 of the German Urheberrechtsgesetz, in Section 62 of the United Kingdom Copyright Designs and Patents Act 1988, and it exists in several other countries or even a large majority of member states. There are also European countries such as Italy and Iceland, where there is no freedom of panorama at all. In Italy, despite many official protests and a national initiative led by the lawyer Guido Scorza and the journalist Luca Spinelli, the publishing of photographic reproductions of public places is still prohibited, in accordance with the old Italian copyright laws made more restrictive by a law called Codice Urbani, which states, among other provisions, that to publish pictures of cultural goods for commercial purposes it is mandatory to obtain an authorization from the local branch of the Ministry of Arts and Cultural Heritage, the Superintendenza. Some countries, such as France and Belgium, do not have global permission for making images of an artistic creation, like a piece of architecture or sculpture, in public spaces and allow images of copyrighted works only under incidental inclusion clauses. In France, the authorization of the author, but not of the owner, is thus required if the piece is not just used secondarily or as a background on the image but intentionally or as its central and essential motif. Litigation. An example of litigation due to the heterogeneous EU legislation is Hundertwasserentscheidung, a case won by Friedensreich Hundertwasser in Germany against a German company for a photo of an Austrian building. While not related to copyright, but to Codice Urbani, a case which reached a national Supreme Court is Ministero dei Beni dell'Attività Culturale vs. Stone Age S.R.L. Australia. In Australia, freedom of panorama is dealt with in the Federal Copyright Act 1968, Sections 65 to 68. Section 65 provides, the copyright in a work that is situated, otherwise than temporarily, in a public place, or in premises open to the public, is not infringed by the making of a painting, drawing, engraving or photograph of the work or by the inclusion of the work in a cinematograph film or in a television broadcast. This applies to any artistic work, as defined in paragraph of Section 10, a work of artistic craftsmanship. This means that other artworks, such as murals, are not covered by this provision. Section 66 of the Act provides similar exceptions to copyright infringement for buildings. Canada. Section 32.2 of the Copyright Act states the following: it is not an infringement of copyright for any person to reproduce, in a painting, drawing, engraving, photograph or cinematographic work, an architectural work, provided the copy is not in the nature of an architectural drawing or plan, or a sculptural work of artistic craftsmanship or a cast or model of a sculptural work of artistic craftsmanship. that is permanently situated in a public place or building. The Copyright Act also provides specific protection for the incidental inclusion of another work seen in the background of a photo. Photos that, incidentally and not deliberately, include another work do not infringe copyright. United States. Under copyright law of the United States, there is no such encompassing rule. The only similar article is 17 U.S.C. 120, which exempts the creation of pictorial representations of buildings from the architect's copyright. This freedom of panorama for buildings does not apply to art. However, former USSR, almost all countries from the former Soviet Union lack freedom of panorama. Exceptions are 3 countries, copyright laws of which were amended recently. First was Republic of Moldova in July 2010, when the law in question was approximated to EU standards. Armenia followed in April 2013 with an updated Armenian law on copyright. Freedom of panorama was partially adopted in Russia on October 1, 2014. From this day, 2-dimensional works. The precise extent of this permission to make pictures in public places without having to worry about copyrighted works being in the image differs amongst countries. In most countries, it applies only to images or 3-dimensional works that are permanently installed in a public place. Permanent, typically meaning for the natural lifetime of the work. In Switzerland, even taking and publishing images of 2-dimensional works such as murals or graffiti is permitted, but such images cannot be used for the same purpose as the originals. Public space. Many laws have subtle differences in regard to public space and private property. Whereas the photographer's location is irrelevant in Austria, in Germany the permission applies only if the image was taken from public ground, and without any further utilities such as ladders, lifting platforms, airplanes, etc. Under certain circumstances, the scope of the permission is also extended to actually private grounds, e.g., to publicly accessible private parks and castles without entrance control. However, with the restriction that the owner may then demand a fee for commercial use of the images. In many Eastern European countries, the copyright laws limit this permission to non-commercial uses of the images only. There are also international differences in the particular definition of a public place. In most countries, this includes only outdoor spaces, while some other countries also include indoor spaces such as public museums. There has been a controversy among Filipino photographers and establishment managements. On June 12, 2013, Philippine Independence Day, pro-photography group Bawal Mag-Shoot Ditto launched the Freedom to Shoot Day protest at Luneta Park. The group is protesting for their right to take photos on historical and public places, especially in Luneta and Intramuros. The park management imposes a fee for DSLR photographers to shoot images for commercial purposes, but it was also reported that security guards also charge 500 pesos to shoot photos even for non-commercial purposes, an act which the advocacy group branded as extortion. The group also claimed that there is discrimination against Filipino photographers and claimed that the management is lenient on foreign photographers. There is no official policy on taking photographs of historical places, and the group has called legislators to create a law on the matter. Anti-terrorism laws. Tension has arisen in countries where freedom to take pictures in public places conflicts with more recent anti-terrorism legislation. In the United Kingdom, the powers granted to police under Section 44 of the Terrorism Act 2000 have been used on numerous occasions to stop amateur and professional photographers from taking photographs of public areas. Under such circumstances, police are required to have reasonable suspicion that a person is a terrorist. While the Act does not prohibit photography, critics have alleged that these powers have been misused to prevent lawful public photography. Notable instances have included the investigation of a schoolboy, a member of parliament and a BBC photographer. The scope of these powers has since been reduced, and guidance around them issued to discourage their use in relation to photography, following litigation in the European Court of Human Rights.